Imagine a single Supreme Court decision that could reshape the American political landscape for decades, potentially handing Republicans a firmer grip on Congress and silencing voices from minority communities. That's the stakes in this high-stakes legal battle over voting rights. And it's not just about the South, it's about the very fabric of democracy itself. But here's where it gets controversial. What if the court decides that fighting racial discrimination in voting is outdated, opening the door to unchecked redistricting? Stick around, because the details might surprise you. Protesters waving signs championing minority voting rights gather outside the U.S. Supreme Court in Washington, D.C. in March. Photo by Jamal Kaunis, Getty Images for Legal Defense Fund. A pivotal redistricting lawsuit revisiting the U.S. Supreme Court this Wednesday has the potential to not only seal the fate of the Federal Voting Rights Act, but also pave the way for Republicans to secure numerous extra seats in the House of Representatives. Should the justices strike down Section 2 of the Act, a key part that forbids racial bias in elections, Republican-led states might redraw at least 19 additional House districts to favor GOP candidates. As outlined in a fresh analysis, https://wpcontent/uploads/2025 Fair Fight Action X Black Voters Matter report from advocacy organizations Black Voters Matter Fund and Fair Fight Action. Depending on the timing of the court's verdict in the matter dubbed Louisiana versus Callais, https://supremecourt.gov/filename/docket/docket-files html/public/24109, several of these districts could be redrawn ahead of the upcoming midterm elections next year. This development aligns with President Trump's ongoing GOP campaign to reshape electoral maps in places like Texas, Missouri, North Carolina, and beyond, aiming to maintain their narrow House edge after the 2026 vote. Such Republican initiatives could gain significant momentum from a Supreme Court decision that dismantles Section 2's long-standing safeguards against weakening the combined influence of racial minority voters. Backers of this historic legislation are deeply worried about this scenario, especially after the court's conservative majority chose not to decide the Louisiana case last session, and instead opted for an unusual second set of oral arguments, likely centering on whether Section 2's redistricting rules align with the Constitution. A decision weakening Section 2 could ripple through congressional boundaries in predominantly southern states where Republicans hold sway over both legislative branches and the governor's office, or enjoy veto-proof majorities, and where elections often divide along racial lines, with black voters generally supporting Democrats and white voters leaning Republican. Without Section 2 mandating districts that give minority groups a fair shot at electing their chosen representatives, states like Louisiana, Florida, Georgia, Missouri, North Carolina, and Texas might see fewer Democratic lawmakers in Congress. The report indicates that Alabama, Mississippi, South Carolina, and Tennessee could end up without any Democratic representatives at all. Furthermore, up to 30% of the Congressional Black Caucus and 11% of the Congressional Hispanic Caucus could vanish. This scenario might solidify Republican dominance in the House for generations, warns Cliff Albright, co-founder and executive director of Black Voters Matter Fund. The core message of our report is that events in the South have nationwide repercussions. Albright elaborates. This form of racial gerrymandering doesn't just undermine black voters and erase Black and Latino elected officials, it affects the whole nation. But here's the part most people miss. How could overturning Section 2 unleash a redistricting free-for-all? In the Louisiana lawsuit, a federal court mandated that the state's GOP-controlled legislature create a new congressional map after black voters filed a complaint citing Section 2 violations. Section 2 guarantees that all communities of color can engage fully in elections and choose representatives who align with their priorities, explains Alana Odoms, executive director of the American Civil Liberties Union of Louisiana, whose team is assisting those black voters. If these communities can't achieve that, we risk losing something essential to our democracy: true equality in participation and opportunity. The court-approved map used for the 2024 elections, https:/2024/05/125356, Supreme Court Louisiana Redistricting, enabled Democrats to gain a second seat in Louisiana. However, a coalition of self-identified, non-African American voters, spearheaded by Philip Callais, contends that the court's mandated race-focused redistricting to comply with Section 2 is unconstitutional. They draw parallels to the 2023 Supreme Court ruling against race-based affirmative action in higher education. https://openNPR.org/2023-061181138806 Affirmative Action Supreme Court Decision, urging the court to end race-based district drawing under Section 2. During the request for a rehearing in Louisiana v. Callais, the Supreme Court prompted all parties to examine if Louisiana's deliberate establishment of a second majority-minority congressional district breaches the 14th or 15th Amendments of the U.S. Constitution. In their most recent filings, www.supremecort.gov/docket-pdf/24-10944212277 Callais-supplemental-opening-merits-brief.pdf with the court, Louisiana's Republican officials now oppose incorporating race in any capacity during redistricting. Marking a departure from previous administrations, the Trump-led Justice Department, https://www.supremecort.gov/docket-pdf/24-10943354 Robinson v. Callais, also asserts that Section 2's anti-discrimination measures have lost their constitutional footing. Just 2 years back, the Supreme Court dismissed a comparable claim from Alabama Republicans. The justices might uphold the Voting Rights Act as they did in 2023's Allen v. Milligan, notes Atiba Ellis, a professor and associate dean at Case Western Reserve University's law school. Yet, many, including myself, are wary of the court growing increasingly skeptical toward race-aware solutions for enduring civil rights issues. This verdict could mark the turning point where the court deems Congress's efforts to foster inclusive democracy unconstitutional or severely limits them. Amid the current decade's congressional redistricting showdown between Republicans and Democrats, Ellis points out, such a decision could spark a genuine free-for-all, referencing the 2019 ruling. https://supreme.justia.com/cases/588/18/422/tab opinion 4114539 that federal courts cannot challenge partisan gerrymandering. Politicians from both parties have always leveraged their authority for bold power plays, but Section 2 has been the crucial barrier against racial discrimination, Ellis reflects. Without that federal protection, the fallout could be profound, echoing through generations. As deadlines for new congressional maps before the midterms approach, Louisiana's chief elections officer, Secretary of State Nancy Landry, has urged the Supreme Court, https://supremecourt.gov, docket PDF 24-14109-2350917095276993q4.pdf. The supplemental brief by early January 2026 to prevent chaos in the state's timeline. Still, the court's schedule is uncertain, with major decisions typically announced near the end of their June term. The court has indicated https://supremecort.gov/search.aspects filename/docket/docket files/public plans to evaluate next month whether to hear a North Dakota lawsuit. https://npr.org.25.6.nxs1 548286 SCOTUS Voting Rights Act 8th Circuit VRA. Questioning if private citizens and organizations, which have primarily enforced Section 2 through lawsuits, can continue filing suits. Mississippi Republicans have similarly challenged this in another redistricting appeal. https://www.supremecourt.gov/docket files/html public do 5 html. For beginners wondering what this all means, let's break it down simply. Redistricting is the process of redrawing electoral maps based on population changes, which can determine who gets elected. Section 2 of the Voting Rights Act prevents practices that discriminate against minority voters, like drawing districts that dilute their voting power. Think of it as a safeguard to ensure everyone has a fair chance, much like how traffic rules prevent accidents on the road. But critics argue it goes too far by focusing on race, akin to debates over affirmative action in schools, where some see it as necessary equality, others as unfair favoritism. This brings us to a controversial twist. Is prioritizing race in voting maps a path to fairness, or an overreach that ignores individual merit? And this is the part that could ignite heated debates. Does eliminating Section 2 truly level the playing field, or does it empower those already in power to entrench inequality? What do you think? Should the court uphold these protections to protect democracy's diversity, or scrap them for a colorblind approach? Share your views in the comments. Do you agree this could be a tipping point? Or is there a counterpoint I'm missing? Let's discuss.